Hi, good afternoon. I am so pleased to be here in one of the first panels of the future of our digital world, and placing humans back in power and giving users the control of what is going on is crucial for the future, because I see this as actually returning back into where the internet used to be. My name is Karen Melchior, and I'm the moderator of this debate. I'm an MEP, that is a member of the European Parliament from the Danish Social Liberal Party, and I've been a member of the European Parliament since 2019. I am the so-called coordinator in our Legal Affairs Committee, and we have just been voting on and debating the Digital Services Act today, where one of the goals, at least for me, is allowing users and people to be back in charge. We have a panel this afternoon, which will be in a total of 1 hour. I'll soon give the floor to the panelists one by one to share their brief perspectives of the topic for us. Then we will have a panel discussion, and the audience, you are welcome to ask questions via the Q&A tool for written questions. And for the panelists, please raise your hand for any oral questions to each other. Also, please feel free to share points made during the panel on Twitter using the hashtag Digital Futures Summit. We have a panel of 4 experts who will give their perspective on the topic of meaningful accountability. First, we will start with Ms. Mutale Nkondo, who is the founding CEO of AI for the People, which aims to eliminate the underrepresentation of Black professionals in the American technology sector by 2030. We also have Mr. David Martin, Senior Legal Officer in of Digital Rights in the European Consumer Rights Organization, which is an umbrella organization for independent consumer organizations from 32 countries in Europe, representing them to EU institutions. He is standing in for Finn Mjøstad, who is the head of digital services section in the Norwegian Consumer Council and also the EU co-chair of the Transatlantic Consumer Dialogue Information Society Committee. We also have the pleasure to have Mr. Roger McNamee, who co-founded the Silver Lake Partners Innovation Partners and is the author of Sucked, or Waking Up to the Facebook Catastrophe. And our final expert is Mr. Ravi Nike, who is the legal director of AVO, an international data rights agency, where he's the leading solicitor in the field of data rights and protecting human rights in the digital age. As mentioned, the theme of the debate is meaningful accountability, putting people back in charge. We really want to discuss whether individuals are powerless when they try to invoke their rights against big tech, and also what are we going to do with so-called dark patterns that often prevent us from exercising our rights, and what actions are needed in order to make sure that if we give our consent to something, that it is actually freely given and informed. We need to also look at how we make the role of individual civil society and NGOs empowered to hold big tech accountable. And finally, what we need from governments for meaningful audits of big tech. We will be starting by giving the floor to Ms. Mutale Nkondo. Unfortunately, she's only with us for 30 minutes, so I encourage you to already now ask questions for her in the Q&A thread, and then we'll take a few questions for Nkondo before moving to the presentation from the other panelists. As I said, Nkondo, you are the founding CEO of AI for the People. You have a fellowship at the Digital Civil Society Lab at Stanford and an affiliate at the Berkman Klein Center of Internet and Society at Harvard. Priorly, you have worked in AI governance, part of the team that introduced Algorithmic and Deepfakes Algorithmic Act, and no biometric barriers to the Housing Act. I will stop talking, and please, Mutale, the floor is yours. There might be a problem with the sound. Unfortunately, I at least cannot hear you.
I am so sorry. You would think 17 years into the COVID crisis, I would know how to unmute, but that's apparently not going to happen. I was simply giving my thanks and also apologizing for leaving early because I actually have to speak with a platform company over this very topic. So, in short, AI for the People is a communications firm that I lead, and the people being the citizens of countries all over the world whose lives are being impacted by AI technologies. Our work is looking specifically at the US, where I live, the UK, where I'm from, and increasingly into the EU, where I have many colleagues, and we're asking these questions. The way that we looked at this from an AI for the People perspective were that the individual actors were, were powerless against the forces of private equity that shape norms in Silicon Valley. So, from our perspective, we need what we call a digitally informed citizenry. That is a citizenry that understands how algorithmic decision making, in the case that I'm really interested in on social media, impacts not just our daily lives, so our interactions with each other, being able to see your grandmother or baby pictures, or even one of my favorites, what we ate that day, but democracy itself and our conception of what we think of as a shared truth. The way that we went after that has been over the last 5 years working with members, specifically Black women in the Congressional Black Caucus. The reason that we chose the Congressional Black Caucus in the US, where Black female politicians across the world are the most impacted by cyberbullying and disinformation online. So we knew that we had an interested policymaking body. And we have been crafting legislation that looks at the impact of algorithms. So the first bill that was entered was the Algorithmic Accountability Act, which came forth in 2019. And that was basically saying algorithmic systems do harm to our society. We're actually updating the act right now, and it will be reintroduced on Monday, where we're now beginning to think about language around impact assessment. So, this idea that if an algorithm is shown to be harmful, and the example that we give are the recommendation algorithms that incite extremism in our country, and specifically the ones that recommended the Stop the Steal hashtag to accounts where we've since found through reporting at MIT Press from Karen Home, 65% of the people that receive those messages had never visited the pages on Facebook. So that's a really strong case study. And thinking about how do we regulate to make sure that those algorithms that harm, what Cathy O'Neill would call weapons of math destruction, are not part of our society, but we still make way for the commercialization of algorithmic systems that have a net benefit. So we use the case study of those that are written in programs that mitigate climate change, for example. So from our perspective, there really has to be government regulation because the rule of the company is to increase shareholder value. And as long as algorithmic decision making is monetized through targeting and other processes, we're not going to be able to give power back to individuals like you or I. So I don't want to overspeak because I know our time is limited and mine especially, but that's an overview of our work and how we're entering this conversation.
Looking at the work that you've been doing over the last few years, what are the hopes and requests that you would make for platforms to help ensure a proper democratic dialogue and lifting up and empowering all voices of society online?
For us, we need to, within this legislation, what we really need to do is take control from the platforms to govern what is acceptable and unacceptable speech. Because from a platform perspective, speech that helps them monetize their advertising is acceptable. So that could be anything from xenophobic speech, sexist speech. It could be anti-Semitic speech. It could be anti-Black racist speech. It is, as long as it gets, as long as it garners advertising dollars, then it's acceptable. And then in the US context, we have Section 230 that further operates. So from a legislation point of view, we want to take that away from the platform and say that we have standards around the impact of the tech, of the products that are being released into commercial markets, including this information product that is transmitted over these platforms, and we need to regulate that.
Thank you. You also, speaking at the Federal Trade Commission, you were talking on the importance of dealing with dark patterns and how to mitigate the damage that dark patterns inflict. How do you see that we should further dealing with dark patterns on both sides of the Atlantic? And also, do you see a role for audit firms in holding big tech to account? And the last is a question from Klaus Sander.
Yeah. So in terms of dark patterns, and just to make sure that we're all in the same place, dark patterns are software programs, algorithmic programs that that stop consumers from being able to basically leave websites. So if you log onto a website and it's free for 30 days and you do whatever you're doing for free for 30 days, the idea is on day 28, day 29, or even day 30, you could potentially leave and it would be free. So what happens at that point of exit is that you then get funneled down an algorithmic path where it's impossible to leave. So your credit card details are there and you start to pay for this service. That redirection is the dark pattern. And it happens most commonly amongst across, and this is actually global, the most economically disadvantaged in society, who in the US and in Europe tend to be people of color, tend to be Black people. So what we were saying there is that redirecting action that can take place as users are trying to leave. Number one, they're consumers. And as consumers, they have rights to transparency, which they don't have as users. So there needs to be a redefinition of the legal, of the a legal redefinition of how we enter onto these platforms. So as consumers, we should have a transparent port of exit, and that should be very clear. And then number two, this idea of the redirecting, that kind of action should actually be banned. And what we were talking about with the FTC is this idea of a closed data set. So instead of once I have your data, I can use it for anything, I can even use it against you, being much more strict within law, and this is across on both sides of the Atlantic, around these specific case uses. And the barriers, which I know was part of the question, has been just that people do not understand what we're talking about. So just like I defined dark patterns, they pretend they understand, but at the policymaker level, there isn't necessarily that literacy. So we've spent, and I'm still spending 5 years actually just telling people what an algorithm is so that we can then do the work. And the second part of the question, I'm sorry.
It was concerning whether accounting firms would be useful in holding big tech to account.
I would prefer it was a governmental body or a third party whose interests are the public good. Because once you start having a private company auditing another private company, both the primary interests of both private companies are the shareholder class. I think Roger raised his hand.
Well,
Yes.
may I ask her a question? So Mutali, I'm curious whether you have given consideration to the idea that for algorithms and some of these other systems, that they should be required to demonstrate safety before they
Yeah.
can be deployed commercially.
Yes, and that's an excellent point. Thank you, Roger. Within the Algorithmic Accountability Act, it's a legal idea of impact assessment. We have to be able to show that this is safe. We need standards for safety. We need standards for impact. The problem is within the tech industry, minimum viable products are often released into the marketplace to then be tested on to see if they actually work. Now, what happens if your MVP leads to a dark pattern, leads to human rights abuses, leads to how can we govern for that? So that's something that we are extremely passionate about. And this isn't just about the US, this is anywhere an algorithm is used across the globe.
Thank you so much. Any of the other panelists that want to come in with a question? Thank you so much for being with us, Mutale. And please, if you have any final remarks or advice, Ravi, do you have questions or a point?
Yeah, I was just going to ask a quick question on this point of the ring fencing of data users. So one of the cases we're running in the UK, or in Europe actually at the moment, because of Brexit, is the idea of purpose limitation, limiting data collection to specified, explicit, and legitimate purposes. And this is particularly pertinent when you think about platforms that collect data from numerous different places, Google being a good example, Facebook being another. Have you thought about how purpose limitation might be of application there, and whether the enforcement of those rights might be of assistance?
We haven't thought about that, but I do think it's a brilliant idea, and I would love to follow up with you, because I think that that's going to be a really important way for the future of our work. I grew up in the UK. I was going to say I love the UK, but then that's such a complicated statement. Different Zoom. But one of the things, our work is increasingly taking us to the United Kingdom, because they're starting to see some of the work that we've started in the US and started to think about how would that apply in the UK, as well as we're interested because we have a global vision for AI for being for the people, right? Whoever those people are, what it would look like in Europe. And as we've talked about this kind of limiting the use of data, one of the things that we found from the lobbying class is these case studies that are built on racism often. So I was in a conversation recently with, I was at an event where Clearview AI were presenting, and this idea of ring facing data. I have very different views on facial recognition generally, but as they argued back, they were saying, but if we couldn't share this data with the FBI, with MI6, with the security forces in Europe, for example, then the criminals would get away. And what they meant by the criminals were, it turned out to be Black. So in the meeting, I was like, well, if you're speaking about people specifically, my name's Vitali, just say I'll get away. But this idea of fear, this idea of missing out. So many of the narratives around stopping that ring fencing are about China and what China will do if we ring fence or if we have rights. And I think that that's really, really problematic. And what we need is what I call a coalition of the willing across the world to get together and really decisions about how we're making all the same demands at the same time, because organized people are always going to out-organize misinformed politicians.
Thank you so much, Mutale, for giving your perspective and also replying to questions from all of us here on the panel and in the audience. I will now give the floor to Mr. David Martin, who is leading the European Consumers Association's digital policy team, focusing on privacy, data protection, artificial intelligence, and online platforms. So everything that is happening at the moment. He's been working on digital and ICT issues since 2006. And prior to joining BEOC, in May 2015, David worked at a public affairs consultancy in Brussels and also an EU regional office in Brussels. Please, David, the floor is yours.
Thank you very much. It's a pleasure to be here. And can you hear me okay, everyone? Yes? Okay. And also, again, apologies from Finn. He's sorry he couldn't be here today. So I wanted to start taking a step back, actually, and zooming out a little bit to put the individual, the consumer, in a broader context, in the broader context of the digital world. And there are all these questions that we ask ourselves. So is it fair? What is it like for the consumer in the digital world? Is it balanced? Is the consumer in control? Can the consumer be in control? What would we solve if the consumer is in control? So we've been asking ourselves all these questions that we are discussing here today. And one of the issues that we have identified is something that we're referring to as digital asymmetry. So these are structural systemic problems which are undermining the digital world from a consumer perspective. This digital asymmetry concept stems a little bit from the usual notion of this black box phenomenon, that nobody knows what's going on behind the black box. So this is a bit more developed, basically, and it's basically it amounts to the fact that due to the increased complexities of technology, the increased complexities of the business practices, and the imbalances of power and information which we find in the digital world, we are all put at a situation of vulnerability, basically constant vulnerability. So we are powerless, to sum it up. The second conclusion we arrived to is that actually businesses or business models that are built on exploiting and built at the expense of people's rights and freedoms are actually thriving. So we see these problems, and then we look into how they're manifesting. And the issue of dark patterns was actually mentioned, and is a very good example of how these more systemic problems are manifesting in concrete practices. So for a start, we have a little bit of a broader concept in terms of what a dark pattern is. So it wouldn't only be an algorithmic practice. It would also relate to how a page is visually designed, for example, where you highlight specific options so that you actually nudge consumers to choose those options, which in turn might be options which are not in the best interest of consumers. So that's a main issue here. So our Norwegian member, the Norwegian Consumer Council, for which Finn works, has done quite a lot of research on dark patterns. In 2018, they published a report entitled Deceived by Design, which looks at how three companies, in this case it was Facebook, Google, and Microsoft, were using these so-called dark patterns to nudge users into making choices which were not good for their privacy. Then in 2018, again, they published another report which analyzed how Google is nudging users or tricking users into sharing location data, so activating location tracking. And in fact, on the basis of this report, BEOC, with some of our members, we launched what we call a coordinated GDPR enforcement action, which is basically we submitted a series of similar complaints against Google in different jurisdictions to tackle these practices. And these complaints are now in the hands of, I'm sure you guessed it, the Irish Data Protection Authority. So we're waiting to see how that turns out. And there's another report which they published earlier this year about Amazon, looking at how Amazon is keeping consumers subscribed to Prime, so Amazon Prime. So there's all these practices that we see all around us. Basically, we're being constantly pushed into making choices which might not be in our own interest. So we're talking about hidden defaults, we're talking about confirm shaming. So when you try to leave and they tell you, are you really sure you want to leave? You say yes, yes, and then they say, are you really, really sure you want to leave? And then if you want to leave, you have to really scroll down and actually find it's not easy to find the leave option. Also how pages are visually designed. So they are used in all different areas, and they lead us to share more data than what we would be willing to do. They lead us into buying things that we wouldn't buy otherwise. And all this is done using the behavioral biases that companies learn from all the profiling and tracking that they do of users, and they are used against us to undermine our freedom and of choice. So companies can do this because of this issue of the digital asymmetry that I mentioned before. They do this because they can, they have the technology to do it, and because they make money this way. And at the end of the day, basically no one or nothing is stopping them from doing these kind of things. So then the question turns back to the beginning. So what can we do about this? And often one of the first answers is, okay, we have to empower the consumer. We have to make them better informed, more aware about what's going on so that they can make the right choices. And I wanted to say, first of all, loud and clear, that yes, this is important. Yes, this is key, but this is not enough. This is not gonna help us address all these different issues that we see in the online economy, in the online world, disinformation, manipulation, exploitation. All these problems will not be solved only through information and choice. And first of all, because you cannot put all the burden on the consumer. So you have to be a financial expert to manage your mortgage. You have to be an energy expert to manage your energy subscription. Now you're going to have to be a data protection expert to manage your PIMs. And since they are all experts here, I don't need to explain what PIMs are. I would just say that they are not the famous British cookies. So we see that there's these systemic problems, and unless we change things substantially and address the business models and the business practices that are really undermining our rights and freedoms, all we're gonna get is an enhanced illusion of control, let's say. So for example, good luck trying to control your data when it goes into the advertising jungle, let's say the ad tech jungle. I mean, no matter how good your PIM is or how nice the cookie banner you clicked on was, control is impossible in the way things work now. And we really have to address these structural problems that we see. So I'm talking about the digital asymmetry. I'm talking about market failures. We have monopolies, oligopolies, abuses of power, of market power. We have unfair commercial practices online. We have illegal data protection practices, you name it. So we really need regulators to step in and regulate all these things in a decisive manner. We need to deal with these business models that are at odds with our rights, as I mentioned before. It's not only through transparency and control that we're going to get to a fair digital world or future that we would like to have. And this turns me to my last point, which is about the role of the EU or the role of consumer organizations as well in civil society. I think that the EU, generally speaking, can be a leader in this and has to be a leader in this field. It has to raise the bar, push it as high as possible, and hopefully others, and here I'm looking at the US, for example, are going to follow our lead. And concretely, I could have a very long shopping list since we are working on all these different legal instruments I'm going through. But I will just mention a few things to conclude. The first one is enforcement. We really need enforcement of the existing legislation, like the GDPR and Unfair Commercial Practices Directive. We need to give enforcers the right tools and the capacity and the resources that they need to enforce the rule properly. So here I'm looking mostly at member states, I guess, at the EU countries. Then I'm really looking at all the policymakers in the room. We need to be ambitious with the DSA, with the DMA, with the AI Act, with the Data Governance Act, with all these rules that are going through the system now. We need to make sure that we take measures that are really going to change things. for example, with regards to our patterns, but also with regards to other things like surveillance advertising. We should really ban surveillance advertising, not only in a political context, I would say. And we also need the strong e-privacy regulation. And just to finish, what we really need is to make sure with our regulation and with all our tools, make sure that consumers can use digital services and that people can participate in the digital society without having to give up their rights. I think that there's a lot to do. There's a lot that the EU can do, and all eyes are on us. Sorry. So let's not disappoint, I would say.
Thank you very much, David. There is indeed a lot to do, and there is more to talk about, and we're looking forward to the questions at the end of the panel. We're moving on to Mr. Robert McNamee, who, as I said, co-founded Silver Lake Partners and Elevation Partners, and has been engaged in a campaign to trigger national conversation about the dark side of social media. He is the author behind the book Zucked, Waking Up to the Facebook Catastrophe, published in February 2019. And I'm looking forward to hearing what you will say regarding accountability and the business models of the internet platforms. The floor is yours, Roger.
Thank you, Karen. So I just want to thank you all for giving me this opportunity. And I especially want to thank this panel, which is a group of extraordinary people, all of whom I find amazingly inspirational. So I have been involved in Silicon Valley as an investor and now as an activist since 1982, so just about 40 years. I believe policymakers continue to underestimate the danger posed to civil society by the culture of the technology industry, but also they underestimate the danger of the current business model of internet platforms like Facebook, like Google. The same is true of artificial intelligence, smart devices, cryptocurrencies, and several other technologies that are in development. Policymakers implicitly accept the status quo. They accept the argument that Silicon Valley's vision is inevitable, that no other reality is possible. I dispute all of this. Policymakers should be asking a fundamental question about every technology that wants to come to market. And that question is this system legitimate? The answer today, more often than not, is no. Far too many technology products are unsafe. Humans are losing autonomy. Civil society is coming apart. And none of this is inevitable. We can stop it. We just need the will. The culture of technology, of the industry, is based on two deeply flawed premises. The first, new technology is always better. And the second, anything that works technically should be a product. I disagree with both of those premises. Operationally, efficiency, scale, and speed are the only considerations for technology companies. The business model that Professor Shoshana Zuboff calls surveillance capitalism is the primary monetization engine for Silicon Valley's corrupt culture. Convert all human experience into data, use the principles of behavioral economics to build models that allow you to predict behavior, and recommendation engines that allow you to manipulate it. Apps like Facebook transformed marketing by providing access to the inner self, the most fundamental beliefs and behaviors that define us, the things that historically we do not share in public, the things that can and should be kept hidden. The inner self is valuable to all marketers, but none more so than scammers and those who seek to disrupt the social order. Facebook and others might have taken steps to block these bad actors. Instead, they catered to them and built businesses that are optimal for them. In the US, this led to anti-vaxxers undermining our response to the COVID pandemic. It led directly to the insurrection at the US Capitol. These were not accidents. They were the predictable and catastrophic outcome of dangerous systems that are out of control. Human decision-making has evolved much more slowly than technology. So humans are no match for the system of artificial intelligence, behavioral economics, and surveillance capitalism that is the foundation of Facebook, Instagram, YouTube, Google, Amazon, and others. Civil society is not prepared to defend against Silicon Valley's vision of AI, smart devices, facial recognition, or cryptocurrencies. Antitrust fines or privacy systems like GDPR, the California Computer Privacy Act, are no longer the right approach. The threat has escalated far too much. Tech giants behave like unelected governments. We need to approach them as we would hostile foreign governments. We need systemic approaches that prioritize the needs of society and citizens. We need to ban surveillance capitalism and force every technology product, including every product that's in the market today, to prove that it is safe before allowing it to operate. Dystopia is not inevitable. With appropriate incentives, engineers will once again make products that help humanity flourish. Engineers are used to working with constraints. The problem that has happened over the last 15 years is we removed all the constraints. We need to put them back exactly as we did with the chemicals industry, exactly as we did with garment trade and other things that use child labor. We need to do what we did with food and drugs back when we regulated them, and with the building trades. We need to make this industry safe. We need to give people back their right to self-determination. It's within our power. The only question is, do we have the will to do what it takes?
Thank you very much, Roger, for a slightly dystopian view on our present day relation with technology. Unfortunately, I think this is quite apt. And the last panelist will be Mr. Ravi Nike. Nike has worked on digital human rights, and his work has led to numerous awards, including being named Law Society's Human Rights Lawyer of the Year 2018 to 2019. Currently, Ravi is a visiting fellow at Oxford University's Internet Institute. Ravi, the floor is yours.
Thank you very much, and thank you for having me here and to be part of this really brilliant panel. So, as you said in your introduction, I'm the legal director of AWO, and we are the first data rights agency that offers public policy, compliance services, and litigation services in one place. And by doing this, we hope to push the boundaries of responsible data use, challenging the deployment of digital technologies, and seek to shape, apply, and enforce data rights around the world. And through that work, we have a relatively unique insight into how individuals try to stand up for their own rights and what fundamental human rights principles mean in practice. And at the outset, it's quite important to make clear that the rights we are discussing are framed in the European context as fundamental human rights. And while the right to privacy is quite well known and a key pillar of the suite of first-generation rights, the right to the protection of personal data is itself a key fundamental right. And those rights, while often overlapping and complementary, are separate and distinct. And this is quite starkly illustrated by the first recital of the key European Charter of Data Rights, the General Data Protection Regulation, GDPR, which says that the protection of natural persons in relation to the processing of personal data is a fundamental right. And this grounding in human rights norms is important because, as you'll know, fundamental human rights norms cannot be bought or sold. They're not a property or commodity. Rather, the GDPR gives individuals inalienable rights to protect their data and control how their information is used. But while those rights are well defined and structured, those rights become hollow unless individuals can stand by them and enforce them. And as litigators, we work within the confines and structures of the litigation process and the court system. And that court system gives us a real unique insight about the journey about holding powerful actors to account and the practical challenges that individuals face in doing so. I think it'll be useful to just outline maybe two of my many cases that go to these points. One of the first challenges that has already been discussed when trying to hold a technology company to account is to understand actually what they've done, to look inside the black box. Our cases often begin with our clients asking quite short and simple questions. Mostly, what are you doing as a company with my personal data? And getting a direct answer, as a lot of our clients will testify, is a lot more complicated than that small question would belie. The first question I'd just like to go quickly, the first case, I'd like to quickly talk about is a case we act for Dr. Johnny Ryan and proceedings against Google. And that case started by Dr. Ryan asking a simple question to Google to explain the purposes, the reasons why they were collecting data. It would seem on its face quite a simple question. The data gathering techniques and the very platforms that Google operates gives them a panopticon view of its users that it profiles. And Dr. Ryan's case is that Google does not specify with any granularity to its users how it actually uses that data that it gathers. Its privacy policies, for example, use vague terms like developing new services or providing personalized services. And that vague description of how these companies operate actually deprives individuals of the ability to exercise their wider rights, and it makes rights hollow. We're currently taking this matter to court to find out the reasons that Google actually collects data and what they do with it. The second case I just want to quickly discuss quite starkly illustrates the problems of automated behavioral segmentation that Mr. McMahon did so well to describe. This case relates to the online gambling industry and how personal data is used to identify and target vulnerable gamblers online. Operators use these behavioral metrics, which can be indicators of addictive or problematic behavior, to deliver targeted messaging and adverts to engage individuals to gamble, even where those individuals are trying to reform themselves and move away from their addictive behavior. Like in our first case study to do with Dr. Ryan and Google, the lack of transparency regarding these practices mean that individuals are most often not aware of how their data is being collected and used by these organizations. The processing is invisible to those it most greatly impacts. Now our client, a reformed gambler, has made access requests to understand how his data is being used within the gambling industry. He asked simple questions about how his data was being used. He's faced practical difficulties with accessing this information. He's now having to take cases to court to start to pick together how he has been profiled and how he's been segmented. And these cases highlight several points that are important to our discussion today. A number of those key issues about practically enforcing rights have already been explored by my other panelists. I just think there's three key areas that I can maybe add to the discussion. Firstly, it's important to show that these cases show the gap between the rights that the law provides and how individuals can practically enforce those rights. They show that trying to hold the powerful actors to account for their compliance with data protection norms and other associated human rights standards can be a difficult process. There are, most importantly, there are power imbalances where on the one hand you have wealthy and resourced organizations and companies, on the other hand you have oftentimes vulnerable individuals trying to take on that powerful institution. And the cost of bringing novel and complex cases against some of the world's most powerful players can be quite prohibitive. Secondly, and related, is the idea of the asymmetry of knowledge. Most of our clients find this opacity regarding how the organizations use their data. It's often referred to as the black box, as David referred to. Whilst most people have heard of companies like Facebook and Google, there's often a wider satellite and galaxy of companies that are much harder to unpack and understand how they operate. And this opacity means that individual data subjects may not realize they're even being profiled at all. And often that profiling happens on their most intimate and sensitive of beliefs. Thirdly and finally, this tangled web of actors involved in processing often contain complicated jurisdictional issues where data crosses across borders. This can be impossible for an ordinary individual to unpick without legal assistance. For example, although we'll be able to bring the two cases I've discussed today because of the relevant US companies had a presence within Europe, and therefore within the GDPR's reach, In other cases, we've experienced US companies relying on the fact they're US based to say that we need to sue outside of their jurisdiction. Conversely, we've had other companies, for example, probably quite most notably Cambridge Analytica, that tried to argue that because they were profiling individuals based outside of Europe, those individuals had no rights. And it took a long, complicated legal fight on behalf of our client, Professor David Carroll, to prove them to be incorrect. Those cases really illustrate that the law in theory is one thing, but the law in practice is very much another. Thank you for your attention.
Thank you very much for your presentation, both Ravi, Roger, and David. I have a full list of questions left listening to you, but we'll start with a question from the audience. This is from Marie-Louise Vinge, who's thanking you for emphasizing how legislation can ensure a more inclusive and human-centered approach to tech. But how could not the legislators, but actually people be put in charge again? So how can we ensure people are being in charge, not through legislation, but through other means? Ravi, is this through cases at the courts? So, and also, please just raise your physical hand if you want to be given the floor.
I'm happy to have a first go. It's a really good question. I would say that actually the emphasis should not be on individuals. The emphasis should be on those controlling our information. They have the power. They should be responsible for compliance with the law. And I think it goes to David's point about a lack of enforcement has been a real problem here rather than a lack of laws. And secondly, I'd say that we are at maybe the start of the legal process with a lot of cases. And I think once those cases get through the courts, we'll start to hopefully see some change.
Yeah. So, Karen, I would suggest in the United States, our laws are inadequate. And importantly, the best way for people to get involved is through political action, to force our policymakers to prioritize these issues. In Europe, the situation is a little bit different. Your democracies are far more functional at the moment than ours is in the United States. And so as a consequence, the options in Europe are different. But I think the basic problem is the same, which is that we've been thinking about the status quo as something that we can't really alter, that we're afraid to make dramatic change. And I think that underlying assumption is wrong, because I think people underestimate not only how adaptable the world of engineering is, but how quickly things that are removed from the marketplace will be replaced by better things. What's missing here is a policy that says that humans need to come first, that technology is not something that should be created to exploit human weakness, but something that should be created to empower humans to be their best selves. And that used to be how technology worked until about 15 years ago. It's not how it works today.
Thank you very much. David, also a slightly follow-up question to this. We're looking at a ban. There's proposals for a ban on targeted advertisement and also a ban on dark patterns. The ban on dark patterns is not quite the ban on targeted advertisement, but would either of these work? And also, please feel free to answer the other question.
Sure. So I will start quickly with your other question, which actually I addressed in my presentation as well. I really think that we need to reset the rules of the game here, and I agree with both Roger and Ravi what they said. But really, there are certain things that certain burdens you shouldn't put on users, and you really need to regulate what companies can or cannot do, and there will be room for users who are more technically savvy to use certain tools to do certain things, for sure. But largely speaking, as a consumer or as an individual, I need to be able to rest assured that certain things are simply not happening and that I'm not faced with certain practices. So I really think that there's a mix of all different things that need to happen in order to be able to meaningfully have some power as a consumer. And just coming to your question on the ban on advertising and dark patterns, first of all, I think we have to be very precise when we're talking about bans, and it's not targeted advertising per se that is a problem. It's a specific type of targeted advertising, which is basically based on tracking and surveying people and exploiting their vulnerabilities, etc., etc. So it's what we refer to as surveillance-based advertising. So that's what we need to ban, really. And on dark patterns, we can adopt measures to tackle dark patterns on DSA and DMA, for example, also on the AI Act when it comes to subliminal algorithmic practices that kind of manipulate people. But we also should not forget that we have the Unfair Commercial Practices Directive, which is key in this debate as well, and which, in our opinion, needs to be modernized to take into account this concept of digital asymmetry. So we need a better concept of fairness, a better concept of vulnerability. And these dark patterns, at the end of the day, a lot of them are just manipulative practices or hidden practices, unfair practices, which in some sense, some of them should already be considered illegal, also under GDPR, for example. So I stop now. I see my co-panelists really want to come in, so I'll shut up now.
Yes, I'll give Ravi the floor and then Roger. You need to unmute yourself.
Sorry, I was offering the floor to Roger because he had his hand up first, but while I'm now on the main screen, I'll provide a quick answer. On targeted advertising, I think one thing that David also said that's really important to emphasize is the legality of the current practices involved in surveillance advertising. Surveillance-based advertising is very questionable. In fact, one of the key cases we are bringing in Europe and has currently subject to complaints across every member state in Europe is about the inherent illegality in surveillance-based advertising. So I think, as David said, treading very carefully when you're thinking about bans, but also looking at the legality or lack of legality of the current system is really worth pursuing.
Thank you. Roger, the floor is yours.
If I can just add to this, the issue that we really face here is that these companies are migrating beyond advertising-based business models. So in the United States, you can see Google, Amazon, Microsoft in particular, but Facebook in its own ways, migrating into systems that control healthcare, systems that control education, systems that control various government agencies. And they're using the same basic notions in all of these products. And so to me, the underlying thing of surveillance capitalism should be banned, that we need to get away from this idea that data about people is an asset that corporations can use as they see fit. That in fact, there should be very clear limits, that some kind of data can only be used in a first party transaction. I would put anything related to health, anything related to financial things, anything related to location, anything related to the activities that you do online. Those things, there should simply be no third party commerce at all under any circumstances for any use other than the original intended first party activity. And that's the way to think about it. If you focus too much on the advertising, you miss that they're going to be next generation products, some of which are already in the market, that use the same basic methodology, but with a different monetization strategy.
Just very quickly on that point, Roger, we are bringing legal proceedings on that point about the manner in which cross uses.
And by the way, both of you are brilliant on these issues. I mean, I'm so violently in agreement with both of you. I just thought I'd make that point because in the US in particular, we are not looking forward at all. We are not anticipating the next generation. In Europe, I think there are a series of areas where your values have caused you to look at the problem in a more holistic and helpful way.
Thank you very much. We only have a couple of minutes left. I would love to hear your thoughts on, if the GDPR is not the right approach or not enough, what do we need? And also the changing of settings and taking on transparency measures. Is that just faking, giving people control of the platforms? But also, I mean, I would love to hear what we need to do in order to go beyond GDPR and where GDPR is not enough. And if you can also use your time to answer to have your final remarks. And thank you so much for being here on the panel.
Well,
David
if I
didn't
can
speak, just go ahead.
So my simple observation here is, again, I think you have to take out the surveillance economy, this notion of commercial use of data about people. Our entire marketing industry is built on it, and they're going to have to rebuild on a contextual model and get away from the kind of surveillance we're doing. I really don't think there's any other way to do this, because these next generation systems are so destructive. You know, if you look what's going on with artificial intelligence, if you look what's going on with cryptocurrencies, even what's going on in video games, all of these things are data surveillance tools, and there's a lot of there are a lot of issues that remain unanswered and absolutely no control of them at all. And I just think with GDPR, again, you're accepting the status quo. Start from scratch. Ask what kind of world you want to live in and engineer for that. The engineers will do that. It will take them almost no time.
Thank you.
You're muted, David.
Yeah, sorry. Sorry, I just wanted to underline first that I think that the GDPR is underused, or let's say it hasn't fulfilled its potential for different reasons. Some relate to how the GDPR was designed, and that can be and should be addressed at a given time. Some other relate to how it's been applied in practice, and there we're running into a lot of issues like the ones Ravi mentioned, but also issues related to how the enforcement system is structured, how the EPAs are using their powers, etc. I think there's still hope for the GDPR to achieve good things and to achieve meaningful change.
Thank you very much. I'll
And with
give the last 30 seconds
just
to
one
Ravi.
thing quick. Okay, sorry.
Go on, David. Finish, quick.
No, I would just say it's not enough, precisely because one thing, it's docked into personal data processing. In the future, all these technologies might not even need your personal data. We need to address the business issue and the surveillance issue in a different way, not only tied to personal data processing.
Thank you so much, all three of you, and sorry that we were slightly running out of time, but there is more to discuss. Have a great rest of the conference.